SJC-13033, Leroy J. Randolph v. Commonwealth.
Good morning, Mr. Traft.
Morning. May it please the court, Madam Chief Justice and Associate Justices, Michael Traft on behalf of Leroy Randolph. I stand here on the appeal issue in a somewhat unusual posture because all three parties in this case agree that someone in my client's position should have an opportunity to appeal. And the only question is, does this statute permit it or not? And I think we've analyzed that in the briefs. And the only thing I would add to what I've already written is that I think I finally figured out the thing that confused me about the wording of the statute, section 18. There's the first sentence that says it's a final order and everybody can appeal, and that so presumably. And then the second sentence says a defendant can appeal after the motion is decided. And I think what that means is we have a defendant who is raising multiple issues, one being a test and one being other issues, jury instructions or witnesses, that they don't have to do a dual appeal. If they denied a motion on the test, they can raise all the rest of the other issues and then raise it all together after there's been a final determination on the motion. And that would mean, I think reinforces my argument that the intent of the legislature here was to give anyone whose rights are affected, and certainly my client's rights are affected by an order of this kind, would have a right to appeal.
But what forum does the appeal fall into?
Well,
That is, how do you square 33E review for murder ones, first degree murders, and this right to appeal that your client has under section 18?
Well, I think 33E doesn't apply because he's not the defendant or the Commonwealth. And the restriction on 33E is really to avoid having multiple appeals that are not meritorious.
Can you address the language in 33E? Because 33E says before rescript, motions for new trial, of course, can be remanded. That's the preceding sentence. So it specifically addresses motions for new trial. And then it says after the rescript issues, any motion is subject to gatekeeper. It's the any motion part that's problematic in this analysis versus the motion for new trial. So how do you get around that very broad language in 33E?
I think I get around it by saying that the review process doesn't apply to a third party. When you're bringing in a third party.
And as you know, and you can appreciate, Mr. Traft, we're trying to look at this case globally because it's going to affect,
absolutely.
Defendants who or the Commonwealth who appeal on the 278A orders, whether or not they apply to the gatekeeper. So not to diminish your client, but I'm looking at it broadly. So you would carve out just third parties?
Yes, I think the defendant or the Commonwealth would have to go through the gatekeeper process.
Okay, that was the answer to my question. Thank you.
All right, so moving on, the next issue that I'll address is the question is this a constitutional search? Now, in initial blush, you look at the Jansen case and say, well, hasn't the SJC already decided this? This isn't a search, it's somebody else who's making the request. But I think the statute is what makes the difference here, because the statute says not only is this information going to be supplied to the defendant for analysis, and that was a pretrial order, but it necessarily will be provided to the Commonwealth. And there's no restriction on what the Commonwealth can do with that at any time in the future, in this case or in the future.
So does that mean we have to reverse Jansen then? If to adopt your position, how do we distinguish Jansen?
I think you distinguish Jansen because it was a pretrial motion, and in Jansen, the court specifically said that if the Commonwealth were to try to use this information in any way against Mr. Jansen, then we have a different story. We may have to use constitutional analysis. They didn't have to deal with it because the question hadn't been raised. So that's how you can distinguish Jansen and apply it in this way and say this is a search.
but that's going to be hard to do in the real world, isn't it, Mr. Trapp? So we're going to have a much lower standard for the defendant to request this information. I get that. But then if that information is damning, how do you unscramble the egg at that point and do the probable cause analysis that you're requiring us to do? I'm not sure how that's going to work. You're going to ignore the results of this. So this is not your client, but say we have compelling evidence that the third party is the murderer. We acquired that. The police acquired that through this process. I mean, this process produced that information. We're just going to ignore it.
No, I think that is involved in the probable cause analysis, actually.
But how do you do that?
You might say, you've got this enough other evidence here to say that this search for that person that you're describing, there would be probable cause to conduct the test.
But are you allowed to use the fruits of the information or not? Because that's going to be the tricky issue, right?
Right.
So,
but I think
so
potentially.
let's play this out for a second. So the test produces compelling absolute evidence that the third party is the murderer. Does the Commonwealth get to use this information in its probable cause filing or no? Because then it's obviously probable cause, but if it's not, there isn't any probable cause, right?
Well, if they establish, remember, of course, we're conducting a search, we don't know what the result is going to be. So
I'm playing the next, as Justice Gaziano says, we're playing the real world out in the next case.
Yes. Right.
So the next case is this produced this compelling evidence that someone's the murderer. Now, how do we do what happens next? Is that information available for the probable cause finding or not?
That information is available to determine whether there's probable cause to do the test in the first place. If you've got other information that you can bring in that now identifies this person as the potential murderer.
No, but I don't. All I had to begin with was the limited amount of information we had, like in this case. But then it produces the grand slam information, which is that the third party is the killer.
Can I just clarify something? Aren't we talking about whether the sample can be taken in the first place and whether there's probable cause for the sample to be taken in the first place?
That's right.
So you don't have Justice Kafka, I don't think you have the results of the test until you have probable cause to get the sample.
Right. And so I understand the problem because you don't want to be in a situation
but I thought we have a lower standard than probable cause at the first step.
Well, not for the third party, right? Not for the third party who's being asked to give, who's being asked for the sample.
That's right. You have a higher standard for the third party to begin with. But even on top of that, I'm saying you have to have probable cause for the third party. So you've got to have more.
So really you're adding something to the statute that you're saying is justifiably there because of the Constitution.
Correct. That's right.
Right. So it's really, we're dealing with
that,
two tests.
But
Right.
that skips a step that opposing counsel might disagree with. You might be absolutely right, but there is an argument to be made that there doesn't have to be a constitutional analysis because there's no state action. Now, I'm not sure that's right, considering that the courts have to enforce it. You've got potential contempt. The Commonwealth is going to get the test results. But is your view is that for a third-party search, there has to be a constitutional hurdle, but that's not necessarily the view of the Commonwealth or the defendant.
Well, I'm sure they'll argue opposite, correct. But that's my view is that the Constitution demands.
I understand, and that absolutely might be correct, but if it isn't, we got to play out this whole thing.
Right. And that's where we get to if you want to get to the next step of I still think you don't satisfy the statute, even if you disagree with my constitutional analysis, you still don't satisfy the statute. On this, the statute.
Can I ask you before you move to the statute? Sorry, counsel.
Sure.
Given that the statute requires a preponderance of the evidence standard, doesn't that subsume the constitutional probable cause standard?
Not necessarily. And I'll try to explain that in the context of this case. In dealing with probable cause, you have to deal with all of the circumstances. Now, if this event had happened a month ago, and you only had maybe 1 or 2 people who touched this knife, and the police are a lot more aware and make sure that they don't potentially contaminate a DNA. And you have a person who has denied that he had any responsibility, but you have 2 people who also said he did it, that he admitted that he had thrown the knife. So, and none of those witnesses have been tested. In this case, my client had testified at the trial. He was cross-examined. The 2 witnesses who claimed that he had thrown the knife also testified at the trial. The jury finds beyond a reasonable doubt that the defendant was the murderer. Now, they couldn't have found that, and you've just recently in the Colas case reiterated this. They couldn't have found that this person had committed the murder unless he had thrown the knife. So they must have believed my client and disbelieved these other 2 witnesses. And then 4 more witnesses come up and talk about admissions by my client. And the trial judge hears a motion for new trial on that. He sat, of course, through the trial. So he's evaluated the credibility and he's determined they're not credible. So that changes the whole probable cause analysis.
The statute also, so it's preponderance of the evidence, the statute, unless I'm misremembering it, the statute also requires that it be material to the identification of the perpetrator, correct?
Yes.
So we have something more than probable cause for legal standard plus materiality, right?
Right. That's right. And so, and that's what I was going to get to with the statute. I think, first of all, I wanted to clarify one issue that's been raised with respect to what my client can challenge. There's the 7B analysis that has a list of 6 items that must be established, and it's at a lower standard. And the argument has been that that he has no standing to challenge the judge's earlier decision. Well, I think since he hasn't been notified or been allowed to participate about it, if there is any flaw in meeting those conditions, he has a right to challenge those when he's had an opportunity to be in the case. And certainly the judge can.
Yeah, I had a question about that.
Sure.
Is your client's position that the testing of the knife shouldn't have happened to begin with because 7B was not met? Or is it in the context of 7C, you're saying that the 7B factors are relevant?
Right. I think you have to look at 2 different tests. There's one standard perhaps for a test to see if the defendant's DNA is on this knife. And a different evaluation is required when looking at the third party.
Right. And which one are you arguing? Are you saying that the test of the defendant's DNA was not appropriately allowed?
No, I'm not contesting that. I'm only contesting applying it in the context of my client.
But again, this has to be a materiality. So if you're arguing that the Section 7 standards weren't met, say for instance that it wasn't stored properly, or everybody and his brother and the jury grabbed the knife and the DAs and the defense attorney grabbed the knife, that's one thing. But you could argue, or your client could argue, that it's not material, the testing wouldn't be material, wouldn't lead to reliable results because it was mishandled or not stored properly. So that would be subsumed in the materiality analysis, correct?
It would be, yes.
Would also, on that line, Attorney Kraft, would that also include the reliability factor of this true allele issue? Would that end up bumping into the materiality analysis also?
Yes, that's correct. Because what you're talking about is the kind of test, and you have to look at the kind of test in the context of what you're dealing with.
But that fits into what the other side says, because your client's not part of the Section 7 analysis. He is part, of course, of the materiality part of it, so that he can participate in, he has the ability to protect his rights by arguing it's not material. He has no say in the discovery parts of this motion.
Well, I think
Because that horse is out of the barn.
No, I don't think so, because you're talking about a new test. Every test has to be evaluated as to which, whether that test is appropriate
your
or not.
client can go back in time and say, you never have gotten the discovery?
No, I am not really saying that. And as I said, I'm not really challenging whether they did the test appropriately for the defendant's DNA. What I'm saying is when you want to bring in a third party, you have to look at you have to relook at all those issues again and say, is it going to be
Well,
material?
we may be saying the same thing because it might be in the context of materiality, so I don't
Yeah.
want to waste your time with that.
Right,
But-
I mean, and it's, this isn't easy, and I understand the concern the court has to try to struggle with this. But I think I would suggest, in terms of looking at the reliability of this test, the Gisson-Tanner case gives a good summary. It's a great analysis by the judge. I don't know if you've had a chance to read that thoroughly. It takes a while for those of us who aren't
The
scientifically.
motion judge didn't spend any time on this or much time on this, but we have to defer to those findings, correct?
Right. That's right. I mean, we didn't have we didn't have any experts who testified that this was just the request. But I think this is a preliminary request in that sense. And that's where I'd get into my, I'd also suggest that the Sixth Circuit has an excellent oral argument. It's worth hearing if you haven't had a chance to do that, that discusses all of the issues about the test. But if you don't agree with any of what I've said and you want to go forward with the test, I would request that the court issues a protective order for this defendant in this circumstance, in this case. It doesn't necessarily have to apply to any other cases.
Did you mean to say this defendant?
This, I'm sorry, my client, not
Well, can we go back to that for a minute, and think about other cases? The statute, does the statute have any limitation on what kinds of cases it can apply to?
it doesn't have any limitation, except that it, I think it doesn't require that it applies to a criminal case, but,
A criminal case, but
right.
so for example, it could apply to a rape case.
oh, absolutely.
So theoretically, you could have years and years later request that because of new technology, that a victim be retested for some
Yes.
kind of something.
That's correct.
Are you asking that it not go into any type of registry? Is that the protective order?
Well, certainly, yes. I would ask that, that it wouldn't go into any registry. If you'll indulge me, I'll give a slight example of my own personal experience. Let's say an intruder came into my personal residence and touched the handle that opens the door. And my wife and I live there. We've both touched it. Our DNA would be on it. Our sons visited us over Christmas, 2 sons. Their DNA would be on it. We had 2 repair persons who came into the house, all in this last 3-month period for a short period of time. Their DNA would be on it. Now, in order to do a DNA test of 6 or more people, if you can get the DNA of people you know might be on there, you can eliminate them and you might be able to identify the person much better. So we would be happy to donate our DNA, my family and I, if we could find out who that intruder is. But not if our DNA now is going to be in the Commonwealth's hands and could be used as a registry forever. And certainly, we had a young Black person who was one of the people who came in to do the repair work. He certainly doesn't want he just had no connection to this case, to this situation. He certainly doesn't want his DNA in there. So there has to be a limitation on how you use the DNA. It goes back to what I said about, I think Justice Scalia.
And
was
your
right.
client suggested the terms of a protective order, I assume, and that's in the record?
No, we didn't get that far, because the only issue we were arguing is, can you do the test at all?
Okay, so
And
your
when then the
client did
judge
not
said-
argue in the alternative, don't put my DNA in the registry if you allow this motion.
Not specifically, because we're focused on whether you can do the motion at all.
And you're
then the
suggesting
judge-
that doesn't constitute a waiver of that argument?
No, it doesn't, because the judge said, now, I'm going to order that, yes, they can do the test. You people can work out who you want to do the test with, make a decision, and then if you disagree, then you can come back. So I understood that to mean that to the extent that I wanted any restrictions on the use of how this test was going to be conducted, by who, and what the use of it was, are things that I could raise subsequently. So that's the way I approached it. I didn't consider that a waiver at all. I didn't want to get into that really, because then you get into, do you need to have expert testimony about this, or other issues that really weren't presented at that point.
Okay. Does anyone have any other questions?
No, thanks.
Okay,
Okay.
great. Thank you so
Thank
much.
you.
Okay, next we have Attorney Knight.
Good morning, and may it please the court. Erin Knight on behalf of the Commonwealth. I have a short time to speak to you today, but I think the merits of this case warrant much more time, so I'll try to be brief. This case demonstrates exactly why a third party should have the right to appeal under a statute that's required him to provide a DNA sample that could possibly become evidence against him.
So do you agree with counsel for the petitioner here that that the rules for a third party are different given the terms of Rule 33E than they would be for a defendant who wanted to appeal, or the Commonwealth who wanted to appeal one of these forensic discovery orders?
I think the answer to that is actually in 278A Section 18. In that section, it says that if the orders under this section are final and appealable, and then it makes note of the defendant's ability to bring the motion, to bring the appeal. I think because a first degree murder still falls under 278A, because that enumerated defendant portion of Section 18 is already in the statute, I think that the third party would be able to avoid 33E if he was also enumerated.
Oh,
into
you're
the
talking about the
statute.
third party. I think you misunderstood my question. My question
sorry.
is not this case, but in a different case. If the defendant is denied this discovery and the defendant is the defendant subject to the 33E gatekeeper provision?
I think by the terms of 33E, that could be the case. I do realize that 33E
Well, I know it
says
could be
that
the case. That's why I'm asking you the question is what is
yes,
the Commonwealth's position?
I understand, Your Honor. I think where a 278A, a defendant under 278A has the enumerated right, I think that no matter the crime, it should be able to come under the appellate provision of 278A. But I do recognize the strictures of 33E review and what 33E says regarding after the rescript. So I do believe that's something that this court should enumerate in this opinion if it would be so inclined, but I do think that where it is enumerated in Section 18 of 278A, a defendant, even under a first degree conviction, should be able to appeal under 278A.
But subject to the gatekeeper or not? I guess I'm trying to figure out what the Commonwealth's position is on that issue.
She wants you to figure it out.
I understand.
I know that that's the purpose of oral argument, is so that you'll help me figure that out. And this is your opportunity on behalf of the Commonwealth to give me your position.
Thank you, Your Honor. I do believe that a defendant should have to go through 33E.
Can I
Only
ask-
in cases of first degree, though, obviously.
Justice Wendland, are you content, or do you have follow-up?
I have my answer.
Okay. Do you agree with Mr. Traft? I'm trying to understand what the statute. Such discovery may include items and biological materials that will, by a preponderance of the evidence, provide evidence material to the identification of a perpetrator. Does that mean, is that a probable, does that require probable cause? What does it require? Do you agree that you can't get the DNA of a third party without probable cause under that statute? Is that your understanding of what that means?
My understanding, if you look at Section 7C, it also states that the discovery from a third party is by a preponderance of the evidence. So not only is the Section B of 7 under preponderance of the evidence, but so is Section C.
Right,
So
but I'm confused because and again, I may be misremembering our cases, but we've been very generous on trying to get this type of information because it helps exonerate people. But we haven't looked at it from the perspective of the third party before. So is your understanding that this provides at least probable cause protection of a third party before their DNA? I'm just trying to understand the next step? And my colleagues may be way ahead of me and understand that, but it's your sense that it's a probable cause protection, so we don't have to worry about the constitutional issue that Jansen said there's no constitutional protection, but it sounds like the statute may provide the probable cause protection. Is that your understanding?
I would answer that with yes, Your Honor. I think because it is a preponderance of the evidence standard and therefore the motion judge has to evaluate for that standard, I think the probable cause analysis is therefore built in. I would just...
But I'm confused by the back end of it. The back end of that thing talks about material to exonerating the perpetrator. Material to the identification, maybe that's it. Material to the identification of perpetrator, that protects the defendant and the third party. Yeah, okay, all right.
Correct. And Your Honor, if I may just elaborate a bit further, I see my time has expired. I would just point that in this case, I think that this case is actually a perfect example of why that third party should be able to appeal, because here you have two court-ordered Bodie tests that say there was inconclusive results because of a Lellick dropout. So what are we really going to get by this petitioner's DNA sample? We don't know.
I mean, clearly he's got to be able to appeal. The question is it a 33? I mean, is it a single justice, or does the statute itself provide it? I mean, you can't. I mean, he's got to be able to appeal it.
Correct. And I would just say that the Commonwealth's position here is through the statute, because if you take a look at 211.3, and I know we are here on 211.3, that doesn't escape me, but 211.3 analysis requires extraordinary review or an extraordinary case. And I think here, this issue could come up before a single justice who believes it to be extraordinary and or one who does not. And so that doesn't get to the merits analysis every single time, which in this instance, the order is based on the merits. So if the order is based on the merits, the third party should be guaranteed a merits review. And 211.3 just doesn't secure that. It doesn't guarantee that for that third party. So by reading into the statute, the ability to appeal, where section 18 already says that any order is final and appealable under this section, and the section or under 278A, and that statute talks about the third party, that third party should have the ability to appeal through the statute to be guaranteed a merits review.
Counsel, do you think there's, oh, go ahead.
Go ahead.
Do you think there's any anything in the Victim's Bill of Rights that would serve to protect this witness or give the witness some leverage?
I'm not sure about the Victim's Bill of Rights in the applicability to a third party here.
Well,
I think
it's about witnesses also in that role.
Correct.
So it does apply to witnesses.
Sure. I think if one of the court's examples earlier in my brother's argument was if a victim was to come back in for some sort of testing, I think there definitely would be there would need to be some careful consideration of the Victim's Bill of Rights in that instance. But I think along those same lines, why not a third party being afforded the appellate rights he should already have? He has constitutional protections. He has the rights. Why should a defendant have more rights than a third party under a statute that's requiring DNA evidence from him that is obviously intrusive, that could lead to a possible prosecution? I think here the crux of the real matter is the purpose of the statute. We all, are here because we support 278A. We have a significant interest in the validity of these convictions, but we also have a significant interest in making sure that those third parties have their ability to be able to appeal a very intrusive order.
And along those lines, counsels, do you agree that the issue of a protective order is to be decided still, or is the failure of the petitioner to raise it a waiver?
Sure. I do believe the way that the judge below was viewing the case is in line with my brother's argument regarding him being able to come back and address it. The parties are supposed to, after this appeal, or if this appeal hadn't been taken, come up with the way and how this is supposed to be. The Commonwealth has taken no position on the merits of the case, and I think as far as a protective order, we would also probably step back here and leave that to argument between my two brothers, just because obviously we have an interest in the results, and I don't want to possibly restrict what we would be able to do with those results should they be material.
Can I just ask, I just want to make sure I understand. So the Commonwealth does agree that this would be a search on the third party? who's being requested for the,
I would like to leave the merits to my brother. I have taken no position in the trial court level, but I do believe that in Reed Jensen is fairly explanatory here.
It says the opposite. It says it's not a search.
Correct. It is a third-party order. I think the government intrusion here, the way that Jensen looks at a government intrusion is the Commonwealth asking for this intrusion, the Commonwealth being the prosecution. Here we also are not. But I do believe that whether or not this is necessarily a constitutional intrusion, I think it's still an intrusion on probably one of the most sacred aspects of this third party's life. And I think that it deserves the protections that we can afford it.
Does the third party get to revisit the 7B factors in their appeal?
I don't believe so, Your Honor. And I would look at both 7B and 7C as they are read throughout the statute. 7B talks about the original motion and the original burden on the defendant. And then I think 7C goes in to say, then in comes the third party. And again, that preponderance standard needs to be met. So I would read it as I read it as almost two separate analyses. And here, as the petitioner did below, the petitioner was given notice. He was able to come in and argue his side of the case, and especially where the Commonwealth took no position on the merits argument below, I think that that then gives the judge another opportunity to look at that preponderance standard in the defendant's showing.
okay, thank you. Attorney Shedd, your
Thank
turn.
you.
Thank you very much. My name is Dennis Shedd, and I'm representing Richard Randolph. I'm not planning to address the procedural issue unless the court has any questions for me on that. As to the merits, 12 witnesses have provided evidence suggesting that Lee Randolph is the one who threw the knife. Only one witness testified that Richard Randolph threw it. And so the issue now before the court is whether comparison of Lee's DNA to the DNA that's been found on the knife will provide evidence material to the identification of the perpetrator. And what I'd like to spend time doing today, if I can, is to focus on some new issues that were raised in the reply brief. Lee cited two new cases to support his Fourth Amendment claim, but neither of those cases raised Fourth Amendment issues. The DeChico case involved a Daubert-Lanigan challenge to an expert's interpretation of a DNA profile, while the Cameron case involved a distinction between inconclusive and non-exclusion DNA results and the necessity for statistical evidence for the latter. So neither of those cases addresses the Fourth Amendment question. And obviously it's my position that the Jansen case is dispositive of the Fourth Amendment issue here.
So, Mr. Shedd, just to play that out for a second, you say you're right, that your client didn't do it, but the defendant did. But the third party did. If this test produces compelling evidence that he's the murderer, so it's not a search, it just seems there's kind of a disconnect there. And I understand exactly what Jansen said, but how is the third party protected? Because normally we don't allow searches. So does the statute provide the equivalent of the constitutional protection for the third party?
Well, a couple of points on that, Your Honor. One is that the preponderance of the evidence standard, I believe, is a higher standard than probable cause. That's point one. The other point is that there's really two separate questions here. One would be
so the statutory protection against this DNA search or DNA investigation is higher than probable cause. So this is,
yeah, I believe, showing by preponderance of the evidence this is material to identification, I think is a higher standard than probable cause. And the Texas v. Brown case I cited in the reply is a case that pointed out that preponderance is in fact a higher standard than probable cause.
So
another point,
your brothers and sisters in the defense bar are comfortable with this argument that to get this information from a third party is a higher standard than probable cause. Because it sounds like you've got a good case for this. You've got 11 witnesses. The next case is not going to be 11 witnesses.
right.
So you're speaking for the defense bar here to a certain extent. I'm just trying to make sure I understand that standard, but Because you're sort of having it both ways. Jansen isn't a search, but at the same time, we don't need to worry because there's plenty of protection up front.
Well, yeah, again, I'd like to point out, though, there are two separate questions here.
Mhm.
One question is whether the acquisition of the DNA and the use of it in the case of Commonwealth v. Richard Randolph implicates the Fourth Amendment. And I believe Jansen answers that question, no. There's a separate question then, is whether the DNA obtained at this point could be used in the subsequent prosecution of Leroy Randolph. And I think Jansen leaves open that there could be Fourth Amendment concerns there. And that those could be addressed in two ways. One is in an effort to subsequently, if the Commonwealth were to try and indict him, there could be a motion to suppress in that subsequent prosecution, or a protective order at this stage could also deal with that should there be concerns that that would implicate the Fourth Amendment. But I think as to the case of Commonwealth v. Richard Randolph, the Fourth Amendment is not implicated by, I think Jansen answers that part of the question, and the Fourth Amendment is not implicated at this stage.
Right, but it just gets hairy when because we got to think of how it's going to be used next. And if it's the compelling evidence that he's committed the crime and it's a lower standard than the constitutional standard, we've got issues, don't we?
Yeah, well, my understanding has been that preponderance of the evidence is a higher standard than probable cause. So if we've satisfied preponderance, we've necessarily satisfied probable cause. But again, I think that's an issue that could be deferred to a further prosecution or be dealt with via a protective order at this stage.
It just seems like
Can
it's
I ask you
little.
a different question?
Yeah.
Sure.
On the materiality, you're looking for handler DNA, and the type of DNA analysis you're looking for is a bit novel. But on handler DNA, you have a whole bunch of people who looked at this evidence, DAs, defense attorneys, jurors, perhaps. How do you get around the concerns that were expressed in Linton about the handling of items that are going to be subject to handler DNA?
Yeah, certainly. I'd like to address that. And that's actually dealt with somewhat by some of the articles that were cited in Leroy Randolph's brief. But first, it's certainly, just to back up a step, Mr. Trapp has looked at the photographs taken of the knife in 2017 and infers from that, well, it's like, the handle may have been handled directly during the trial. I've suggested that, well, there's no exhibit tag on the knife, which suggests it was probably in some container, need not have been directly handled. But it's certainly the case that we can't be certain how the knife was handled at that stage. We don't have a videotape of the trial. But as to whether different people may have handled it, it's not the case that if I handle something and someone handles it after me, that my DNA is gone and only this new DNA is there. And that's the reason why when multiple people handle an item, it's often the case that mixtures of DNA are found with multiple contributors. And in fact, in this case, that's exactly what happened. There's been DNA found on both the blade and the handle, and both have two or more contributors. So the fact that it's been handled subsequently does not mean that the perpetrator's DNA is no longer present. And in fact, in one of the cases, one of those out-of-state cases that Mr. Kraft cited in his brief, the Gates case, is interesting on that point. There, 40 years after a murder, True Allele excluded the defendant as a contributor to items that were used to tie up the victim. The Georgia Supreme Court affirmed a grant of a new trial, and in doing so, it noted that True Allele can reliably interpret degraded DNA, and in that case, the DNA was found to have 3 or more contributors. And it also noted that in that case, there was no question the items had been subsequently handled. And the court noted that the fact that they were subsequently handled did not mean that the perpetrator's DNA was no longer present. And that's also addressed in some of the articles that Mr. Traft cited in his brief. One of them is a 2018 article by Van Oorschot. And at page 151, it refers to a couple of studies. One notes that touch DNA has been successfully detected decades later And even with subsequent handling, it found that the original handler's DNA could persist for a long time. And on page 153 of that same study, it described another study where they had groups of 4 people handle a knife, in fact. And subsequently, they were able to detect on those knives the DNA of all 4 people in every instance. So the fact that it had been subsequently handled did not mean the original handler's DNA was no longer present.
This wasn't the subject of a factual finding, correct?
No, it was not.
Right.
You
so,
mean it was, as far as the
right, as far as the motion judge goes.
no, that was not a subject of factual finding by the motion judge, no.
So this might be something where it would have to be remanded to determine the materiality, given what you just told me, correct?
Well, I think if anything, this strengthens what was before the motion. It doesn't weaken what was before the motion judge originally. You know, the motion judge the arguments about the subsequent handling were made before the motion judge. That was certainly before her.
But we have no
And she
findings on that.
found that she found that the materiality requirement had been satisfied. So that was before her at that point. So I don't think it's, and these articles, you know, the point in those articles just simply strengthens the argument that I had below. Which, you know,
I
highlights
understand your argument. She made the ultimate finding materiality without addressing at any length this argument. But I understand your argument, Mr. Shedd.
Well, the argument about subsequent handling was before her at that point.
No,
That is an
I
argument that was
understood you the first time. I got
made.
it.
Okay, fine.
So
Some
in
other
a
articles.
278A motion, the defendant has a 278A motion. Is Dobie Lanigan gatekeeper reliability the same standard at a 278 hearing as it would be at trial, or is it a lower standard?
In terms of the admissibility, I would think it's pretty similar. I mean, the question in a pretrial stage is whether the procedure is sufficiently reliable to be admissible at trial. And here, where the question is whether the evidence will be material to the identification of the perpetrator, I think certainly the reliability of the technique being used is a factor in making that decision. And you know, that was an issue, and certainly
That was or was not an issue? I didn't hear you.
no, in the court below, there was never a challenge to the reliability of the ability of true allele to analyze the DNA that's been found in this case. That was never challenged below.
Do you think it should have been challenged before the issue of whether the test could be conducted was challenged, or at the same time?
I think it's an issue that could have been raised at that point if it was believed there was an issue as to reliability.
Do you think it's waived at this point? Do you think it's waived for future motions?
For the purposes of obtaining the third party's DNA, I would say yes. It's not been
Well,
raised
not
below.
for obtaining it, but say you obtain it. Can the third party still raise reliability?
Well, if we obtain the DNA, I think the third party no longer has any standing to raise anything.
No standing at that point.
Yeah, if the third party were to be tried on the, you know, if the Commonwealth were to indict the third party as a result of these findings, I think at that stage, the third party could raise a Daubert-Lanigan challenge at that stage, certainly. But I think once the third party, if the third is ordered to give a DNA sample here, I think the third party has no further role to play as far as that.
But so then let me take you backwards. Do you think the third party should have or could have raised reliability and challenging materiality in the initial stages?
Well, I mean, it's my position that True Allele has been validated as a reliable program. So I don't think there's any strong basis to challenge the reliability. But I think if he believed there was an issue there, it could have been raised. It could have been raised, certainly. I believe it could have been raised there.
Okay.
But it was not.
I know.
Can I just,
okay.
I just want to make sure. Can I just ask a quick question before you wrap up, which looks like we're going to have to do?
Certainly.
Yeah. I'm just trying to make sure I understand in terms of the materiality. Was there some evidence, or did the third party say that he had never touched the knife? I'm just trying to figure out if there if there's, what would happen if it turns out that there is some of Leroy's DNA on the knife? Is it that your client, there is no DNA of your client on the knife right now?
Well, my client was
What-
excluded as a contributor to the DNA on the handle.
Okay.
His DNA has not yet been compared to the profile that was subsequently found on the blade. So what happened was I requested to have the test done on the blade after testing on the handle had been completed. And after getting that test done, I asked for also for the further DNA from Leroy Randolph. And the plan was that if we get that, we will then have a comparison of both Richard's DNA and Leroy's DNA to the DNA on the blade, and also a comparison of Leroy's DNA to the DNA that's already been found on the handle. So Richard at this point has been excluded from the DNA on the handle. His comparison has not been made to the DNA on the blade. That's where things stand right now.
Okay, thanks. Thanks very much.
Okay, thank you very much.